I have presided over hundreds of criminal cases during my years on the bench. I have looked into the eyes of murderers who never showed remorse, con artists who believed they could outsmart the law, and grieving families whose pain could never truly be measured by any sentence I handed down. Yet, even after everything I had witnessed, one case still returns to me in quiet moments. It is the one that reminds me that evil does not always arrive wearing the face you expect. Believe me, when that 14-year-old girl walked into my courtroom, I did not see a frightened child. I saw someone studying everyone else. If you've ever wondered whether someone so young could manipulate an entire courtroom, stay with me. Because what unfolded before my eyes challenged everything I thought I understood about youth, innocence, and human nature. Her name was Emily Carter. She was 14 years old. She stood barely over 5 feet tall, dressed in a simple gray juvenile detention uniform, her blonde hair neatly tied behind her head. From a distance, she looked like any teenager who should have been worrying about school assignments, weekend plans, or arguments over curfew. But years on the bench had taught me something that no law school ever could. People reveal themselves long before they speak. As Emily entered, every deputy, every attorney, every member of the jury, and every spectator seemed to hold their breath without realizing it. She wasn't nervous. She wasn't crying. She wasn't confused. She smiled. Not the uncertain smile of a frightened child seeking reassurance. No, it was the smile of someone who believed she had already won. That smile unsettled me more than I wanted to admit. The courtroom doors closed behind her with a heavy thud that echoed across the chamber. Usually, juvenile defendants avoided eye contact. They stared at the floor or searched the gallery for someone familiar. Emily did neither. Instead, she slowly looked around the room. She examined the prosecutor. She studied the defense attorney. She glanced toward the jury box. Then she looked directly at me, and she smiled again. I remember thinking, she's trying to read every person in this room before they have a chance to read her. That is not normal behavior for a frightened 14-year-old. It is calculated behavior. Over the years, I learned that manipulation often hides behind calmness. Innocent people confronted with terrifying accusations usually display confusion, disbelief, or overwhelming emotion. Guilty people are different. Some become angry, others become silent, and then there are the rare few who treat the courtroom like a stage. Emily belonged to that last group. The prosecutor, Daniel Brooks, organized his files with the steady hands of someone who had prepared for months. Across the aisle sat defense attorney Rebecca Collins, whose reputation for defending juvenile clients was well known throughout the state. She appeared composed, but even she stole an uneasy glance toward her young client. That caught my attention immediately. When experienced defense attorneys begin questioning their own instincts before opening statements, they usually sense complications that cannot yet be explained. The gallery was filled beyond capacity. Journalists crowded every available seat. Parents held their children a little closer. Retired detectives whispered quietly to one another. Everyone had read the headlines. Teen accused of poisoning both parents. But headlines rarely tell the truth. They sell curiosity. Courtrooms uncover facts, and facts are often far stranger than rumors. Emily's parents, Michael Carter and Laura Carter, had survived but barely. Investigators alleged that someone had repeatedly introduced poison into their food over several weeks. The symptoms appeared gradual, confusing doctors until specialized toxicology testing revealed a horrifying pattern. According to the charges, the poison had not been administered in a single desperate act. It had been given patiently, methodically. Meal after meal, day after day. That distinction changed everything. Because crimes committed in anger happen in moments, crimes committed through patience require planning. As I reviewed the preliminary filings before the hearing began, one question refused to leave my mind. Why? There was no known history of abuse, no evidence of severe neglect. Teachers described Emily as intelligent, polite, and academically gifted. Neighbors called the family quiet and respectful. Friends claimed they seemed perfectly ordinary, but ordinary families do not suddenly find themselves fighting for their lives after being poisoned inside their own home. Somewhere beneath the polished surface, something had gone terribly wrong. I looked once more toward Emily. She had leaned back comfortably in her chair. She wasn't paying attention to the reporters. She wasn't watching her attorneys. She was watching the jury, one by one, almost as if she were deciding which minds would be easiest to influence. That was the moment I stopped seeing her simply as a child standing trial. Instead, I began asking myself a far more disturbing question. What if everyone in this courtroom had misunderstood who was actually in control? Then the prosecutor rose to deliver his opening statement. He reached into his briefcase, removed a single sealed evidence envelope, and quietly placed it on the counsel table. I had reviewed thousands of pieces of evidence throughout my career, yet something about that envelope made the entire room fall silent, because whatever was inside it. Emily's smile disappeared for the very first time, and when I noticed that change, I realized this trial was about to take a direction that none of us, not even Emily herself, had anticipated. The instant Emily Carter's smile faded, I felt a shift that every experienced judge recognizes but few can adequately describe. Courtrooms have a rhythm. Sometimes the room grows louder, sometimes quieter, and sometimes, without a single word being spoken, every person senses that something irreversible is about to happen. That morning, silence carried more weight than any argument the attorneys could have made. I leaned forward slightly, studying Emily as she tried to recover the confidence she had displayed only moments earlier. Most people would never have noticed the difference. Her posture remained straight, her expression returned to calm. But years on the bench had taught me to watch the smallest details. Her fingers tightened around the edge of the defense table just for a second, then they relaxed. Fear often reveals itself in fragments before it appears on a person's face. The prosecutor, Daniel Brooks, stood confidently before the jury. "Ladies and gentlemen," he began, "this case is not about teenage rebellion. It is not about family arguments. It is about planning, patience, and betrayal." His voice never rose. He didn't need theatrics. The facts were disturbing enough. He walked slowly toward the evidence screen. "You may think that because the defendant is only 14 years old, this must have been an accident or perhaps a misunderstanding." He paused. "You would be wrong." Across the courtroom, I noticed several jurors exchange uncertain glances. That reaction was expected. Age has an extraordinary effect on perception. Adults naturally hesitate to believe that someone so young could carry out a crime requiring calculation over several weeks. The law, however, does not allow sympathy to replace evidence. One lesson I learned decades ago is that justice becomes dangerous the moment we assume innocence or guilt based solely on appearance. Daniel pressed a button, the courtroom monitor illuminated. Instead of dramatic photographs or emotional videos, the first image displayed something surprisingly ordinary. A family dinner. Michael Carter sat beside his wife, Laura. Emily smiled between them. Another photograph appeared, a birthday celebration, then another, a camping trip, Christmas morning. Vacation at the beach. The jury looked confused. Several spectators frowned. Even I wondered where the prosecutor intended to go. Daniel turned toward us. These photographs were taken over the 18 months before the poisoning began. He allowed everyone to study them. They show exactly what neighbors, relatives, teachers, and friends believed. He pointed toward the smiling family, a happy home. Then he lowered his hand. But appearances often become the greatest accomplice in a crime. I glanced toward Emily. Her expression remained unreadable, almost. Her eyes lingered on one particular photograph longer than the others, not the birthday, not Christmas. The camping trip. Interesting. Experienced judges learn to notice what defendants notice. People rarely react randomly, the prosecutor continued. When investigators first interviewed friends of the Carter family, nearly everyone described Emily the same way. He opened a folder, quiet, another page, exceptionally intelligent, another, respectful, then he closed the file. No one used the word violent. He looked directly at the jury. Because the most dangerous manipulation is the kind no one expects. Those words settled heavily over the courtroom. Defense attorney Rebecca Collins rose immediately. "Objection, Your Honor." Argumentative sustained. Daniel nodded respectfully. "I'll rephrase. That small exchange may seem insignificant, but to me it revealed something important. Rebecca wasn't objecting because the statement was legally devastating. She objected because psychologically it was. Jurors remember first impressions. She understood that I instructed the jury to disregard the phrasing while allowing the prosecutor to continue with factual evidence. As Daniel returned to his presentation, he introduced the timeline. The first hospitalization. Laura Carter developed severe stomach pain. Doctors suspected food poisoning. She recovered. A week later, Michael Carter experienced similar symptoms. Doctors believed it was viral. Then Laura collapsed again. This time, her kidneys showed signs of unexplained damage. Still no answers. Then Michael became critically ill. Hospital staff finally ordered extensive toxicology testing. The results stunned everyone. A rare toxic compound was present in both parents. Not enough to kill immediately, enough to weaken them slowly, very slowly. The courtroom remained completely silent. Even the reporters had stopped typing. There are moments during trials when reality becomes more unsettling than fiction. This was one of them. Daniel approached the jury once more. The poison wasn't placed into every meal. He displayed a calendar. It appeared intermittently. Red marks covered certain dates, blank spaces filled the others. The intervals prevented doctors from recognizing a consistent pattern. He turned. Ladies and gentlemen, whoever committed these acts understood patience. That sentence echoed through the room, because patience changes how people interpret intent. An impulsive act can sometimes be explained. Repeated deliberate acts become far more difficult to dismiss. Rebecca stood once again. And the state intends to prove my 14-year-old client developed this sophisticated medical strategy entirely on her own? Her question hung in the air. It was a fair question. I noticed several jurors nod slightly, exactly as she intended. She wasn't defending Emily yet. She was planting reasonable doubt, Daniel answered calmly. We intend to show exactly how she learned. The confidence in his voice immediately captured my attention. He knew something he hadn't revealed. Rebecca noticed it too. For the first time that morning, even she looked genuinely unsettled. Meanwhile, Emily, she still hadn't spoken a single word, not one. She simply watched every exchange as though she were observing a chess match instead of sitting in the defendant's chair. That disturbed me more than I can adequately explain. Children usually seek reassurance from their attorneys. Emily never once leaned toward Rebecca. She never whispered, never asked a question, never appeared confused. It almost felt as though she already knew every move both sides intended to make. Years of judging human behavior had taught me another uncomfortable truth. People who believe they control the outcome often underestimate one thing: evidence doesn't negotiate. And just when I believed the morning couldn't grow stranger, Daniel Brooks reached beneath his table and carefully lifted a worn blue notebook sealed inside a transparent evidence bag. He didn't open it, he simply held it high enough for everyone, including Emily, to see. The color drained from her face. Her confident posture vanished, and for the first time since entering my courtroom, the 14-year-old girl looked genuinely afraid. At that exact moment, I realized the case before me was no longer about whether a crime had occurred. It was about discovering what secrets that notebook contained and why Emily had just reacted as though her entire world had begun to collapse. I have often said that evidence does not speak with a voice, it speaks through the reactions it creates. That worn blue notebook had not yet been opened, no pages had been read, no testimony had explained its significance, and yet the moment Emily Carter saw it, she reacted more strongly than she had to hearing the charges against her. If you have ever wondered how experienced judges recognize when a trial is about to change direction, let me tell you something: we don't simply listen to witnesses. We watch people when they think no one is watching them. Emily's breathing became noticeably faster. She lowered her eyes to the defense table, then quickly looked back at the notebook, as if hoping it would somehow disappear. It didn't. The prosecutor carefully placed the evidence bag on the table. "I'll return to this exhibit later," Daniel Brooks said. Those words were deliberate. He wasn't ready to reveal what was inside. He wanted the jury and Emily to think about it. Psychologically, it was an effective strategy. Anticipation can place more pressure on a defendant than immediate confrontation. When people don't know what evidence is coming, they often begin imagining the worst. I had seen hardened criminals unravel under that kind of pressure. Still, I reminded myself of something every judge must remember. Reactions are not proof, they are clues. The state still had the burden of proving every element of its case. Daniel called his first witness, a paramedic named Thomas Walker. Mr. Walker had been among the first emergency responders to arrive at the Carter home on the evening Michael Carter collapsed. He took the oath, adjusted his glasses, and spoke with the calm precision of someone accustomed to chaos. "When we arrived," he testified, "Mr. Carter was barely conscious. Mrs. Carter was trying to explain what had happened, but she was weak herself." "What did you observe?" Daniel asked. "They both showed signs of severe poisoning, although we didn't know that at the time." He paused before continuing. What struck me was the defendant's behavior. The courtroom grew still. Daniel nodded. Please explain. Most teenagers watching both parents being loaded into ambulances are frightened. They cry. They ask questions. They try to follow us. And Emily Thomas hesitated. She asked whether she would still be able to go to school the next day. A ripple moved through the gallery. Rebecca Collins stood immediately. Objection. Relevance. Overruled. The statement wasn't offered to prove guilt by itself. It was relevant to the witness's observations, Thomas continued. She didn't ask where her parents were going. She didn't ask whether they were going to survive. She only asked whether someone would drive her to school. I watched the jurors carefully. Several looked uncomfortable. One juror slowly folded his arms. Another avoided looking at Emily altogether. I reminded myself not to draw conclusions. Human beings respond to trauma differently. Some become emotional, others appear detached. The law cannot convict someone for reacting unusually. Daniel seemed to understand exactly what I was thinking. He shifted away from emotion. Instead, he focused on facts. Were there any food items collected from the home? Yes. What happened to them? They were turned over to investigators. The prosecutor thanked the witness and called his next witness. This time it was Dr. Melissa Grant, the toxicologist who had analyzed the samples. She carried herself with quiet confidence. Scientific witnesses often become the backbone of cases like these because chemistry has no interest in emotion. After explaining her qualifications, she displayed laboratory charts on the courtroom screen. The substance detected, she explained, was present in multiple food samples recovered from the Carter residence. Daniel asked the question everyone wanted answered. Was the poison evenly distributed? No. What does that indicate? It indicates intentional placement. She enlarged a chart. The contaminated portions were selective. Another chart appeared. Meals consumed only by Michael and Laura Carter contained measurable concentrations. The next slide appeared. The defendant's portions contained none. No one spoke. Even the air inside the courtroom felt heavier. Daniel allowed several seconds to pass before asking another question. Doctor, could this pattern occur accidentally? She answered without hesitation. No. Rebecca approached for cross-examination. She smiled politely. Dr. Grant, science explains what happened. Correct. It doesn't identify who placed the substance into those meals. Correct. And your laboratory cannot tell this jury whether another individual entered the Carter home. Correct. Rebecca turned toward the jury. No further questions. It was a smart cross-examination. She wasn't attacking the science because she couldn't. Instead, she separated the crime from the person accused of committing it. Reasonable doubt often lives in that space. As the afternoon continued, detectives testified about the investigation. There were no signs of forced entry, no stolen property, no evidence that neighbors or strangers had entered the home during the weeks the poisonings occurred. Everything pointed inward, toward someone inside the house, toward someone who had regular access to family meals. Still, circumstantial evidence is not enough by itself. Daniel knew that, so did I. Then came Detective Ryan Foster, the lead investigator. He described interviewing friends, teachers, relatives, and neighbors. Every interview produced the same image. Emily was intelligent, responsible, helpful. Nothing suggested violence. Then Daniel asked one question. Detective, during your search of the Carter residence, did you discover anything unusual inside the defendant's bedroom? The detective looked toward the evidence table. Yes. Daniel nodded toward the blue notebook. Is that the item? It is. Rebecca slowly stood. Her expression had changed. The confidence she displayed earlier was fading. She knew this notebook mattered. The jury knew it too. Even I found myself wondering what could possibly be inside those worn blue covers to provoke such visible fear in a teenager who had appeared almost fearless all morning. Daniel picked up the evidence bag once again. He held it carefully, making sure everyone could see it. This notebook, he said quietly, was hidden beneath a loose floorboard underneath the defendant's bed. He looked toward me. With the court's permission, the state requests admission into evidence. Rebecca inhaled slowly before speaking. Your Honor, we object. The entire courtroom froze because whatever legal argument she was about to make would determine whether the jury would ever learn what was written inside that notebook. There are objections that every judge expects to hear, and there are objections that make the entire courtroom lean forward. Rebecca Collins stood with both hands resting on the defense table, her eyes fixed on me rather than the prosecutor. Her voice was steady, but after decades on the bench, I had learned that confidence and concern often sound remarkably alike. "Your Honor," she began, "the defense objects to the admission of this notebook until the state establishes an unbroken chain of custody and authenticates both its ownership and its contents." It was a legitimate legal argument. No matter how dramatic a piece of evidence may appear, it cannot simply be waived before a jury. The rules exist for a reason. Justice is not served by shortcuts. I turned to Daniel Brooks. "Mr. Brooks?" Without hesitation, he replied, "The state is prepared to establish both." His confidence hadn't changed. If anything, it had grown stronger. That told me something. He wasn't hoping the notebook would be admitted. He expected it. Daniel called the evidence technician, Angela Morris, who carefully described every step taken after detectives discovered the notebook beneath a loose floorboard in Emily Carter's bedroom. Every transfer had been documented, every seal had been photographed, every signature matched. Rebecca questioned her thoroughly. "Did you personally see Emily write in this notebook?" "No." "Did anyone witness her hiding it?" "No." "So you cannot testify that it belonged to her." Angela remained calm. "I can testify where it was found." Rebecca nodded. No further questions. She had made her point. Location alone doesn't establish ownership, but trials are built piece by piece, and I had the feeling Daniel wasn't finished, not even close. His next witness was Special Agent Kevin Marshall, a digital forensic examiner who had assisted local investigators. He carried a laptop to the witness stand. I was asked, he testified, to examine several electronic devices recovered during the investigation. Daniel asked the obvious question, "What did you recover?" "A laptop computer, a tablet, and the defendant's smartphone." The jury listened intently. "Were those devices password protected?" "Yes." "Were you able to access them?" "Yes." "And did your examination reveal anything relevant?" "It did." Rebecca immediately objected. "Foundation sustained," I replied. Daniel adjusted his approach. "Agent Marshall, without telling us your conclusions, explain your process." For nearly 15 minutes, the witness carefully described how deleted files, browser history, timestamps, and cloud backups could be recovered without altering the original data. I watched the jurors' technical testimony can lose people quickly, but Daniel understood that he wasn't trying to overwhelm them. He was establishing credibility. Only after laying that foundation did he ask the next question. What internet searches were recovered from the defendant's devices? The courtroom seemed to stop breathing. Agent Marshall opened a report among hundreds of ordinary searches. School assignments, music, recipes, and social media. There were others. Searches made late at night, repeated over several weeks. Symptoms of slow poisoning. How long do toxins stay in food? Can hospitals mistake poisoning for stomach flu? Undetectable household poisons. Each phrase appeared on the courtroom screen. No one moved. A woman in the gallery quietly covered her mouth. One juror slowly removed his glasses. Another wrote something in his notebook without looking up. I glanced toward Emily. She didn't react this time. She simply stared at the screen, completely expressionless. That, strangely enough, disturbed me more than panic would have. Years of experience had taught me that some defendants prepare themselves emotionally for evidence they know is coming, Daniel continued. Were these isolated searches? No. Over what period? Approximately 5 weeks. And were there any searches conducted after Michael and Laura Carter were hospitalized? Yes. What were they? Agent Marshall hesitated for only a moment. Can poisoning tests prove who did it? The silence became almost unbearable. Rebecca rose for cross-examination. Agent Marshall, anyone using that laptop could have performed those searches. Technically, yes, the Carter home had internet access available to every family member, yes. And you cannot state under oath that you physically observed Emily conducting any of these searches. No. Rebecca nodded toward the jury. Thank you. Again, it was careful lawyering. She wasn't denying the searches existed. She was challenging attribution. As she returned to her seat, I noticed Emily finally lean toward her attorney for the first time all day. She whispered something. Rebecca listened, then slowly shook her head. I couldn't hear the words. Judges rarely can, but body language often says enough. Emily wasn't asking what would happen next. She was asking whether something could be stopped. Rebecca's answers suggested it could not. Daniel approached the evidence table once more. Your Honor, he said, the state has now established the foundation necessary to introduce Exhibit 27. The blue notebook. I reviewed my notes carefully. The chain of custody had been established. The recovery location had been documented. Additional testimony connecting the notebook to the investigation had been presented. The legal threshold had been met. The objection is overruled. You may admit Exhibit 27. The clerk accepted the sealed evidence bag. Daniel walked toward it slowly. If it pleases the court, he said, the state requests permission to read selected entries relevant to the charges. Rebecca closed her eyes for the briefest moment. It lasted perhaps 1 second, but after decades of presiding over trials, I recognized resignation when I saw it. She knew what was coming. Emily looked down at the table. For the first time since entering my courtroom, she would not look at me. Daniel carefully opened the evidence bag and removed the worn blue notebook. The pages were filled with neat handwriting, no drawings, no random teenage thoughts. Every page had been dated methodically, organized, almost clinical. He turned to the first bookmarked page. I'll begin with the entry dated 6 weeks before the first hospitalization. He looked toward me. I nodded, then he began to read. The very first sentence caused an audible gasp to ripple through the courtroom. Even after all the years I had spent hearing confessions, testimony, and unimaginable crimes, I had never expected to hear words like those written by a 14-year-old. I have heard confessions that shattered families. I have listened to recorded phone calls that exposed elaborate conspiracies. I have watched surveillance footage that forever changed the course of a trial, but nothing prepared me for the words written inside that small blue notebook. Daniel Brooks held it carefully, as though he understood that the weight of those pages came not from paper, but from what they revealed about the mind that had written them. The courtroom had become so quiet that I could hear the faint hum of the overhead lights. Every juror was focused on the notebook. Every spectator sat perfectly still, even Emily Carter, who had projected confidence since the moment she entered my courtroom, kept her eyes lowered. Daniel took a slow breath and began reading. Mom says I'm too young to understand consequences. Dad says character is built by making good choices. They're both wrong. People only believe what they're shown. No one reacted immediately. The words by themselves were unsettling, but not criminal. Then he turned the page. The next entry was dated 3 days later. I smiled at dinner tonight. Mom hugged me. Dad said I was proud of me. They never notice what's right in front of them. A murmur swept through the gallery. Rebecca Collins rose to object. Your Honor, the defense renews its objection. These writings are highly prejudicial. I considered her argument carefully. Every judge must balance probative value against unfair prejudice. After reviewing the foundation already established, I ruled that the relevant entries could continue to be read. The jury was instructed that they alone would determine the weight and credibility of the evidence. Daniel nodded and continued. The next pages were no longer philosophical. They were organized. Each entry contained dates, times, meals, observations. Almost like a research journal, one page listed breakfast, another listed dinner. Beside each meal were handwritten notes. No symptoms today. Dose may have been too small. Dad complained about stomach pain tonight. Mom canceled work again. A woman seated in the front row quietly began to cry. One juror stopped taking notes altogether. I looked toward Emily. She remained motionless. Her expression was impossible to read, but something had changed. The certainty that had surrounded her earlier was gone. In its place was a look I had seen only a handful of times in my career. Someone realizing that the version of reality they had carefully constructed was collapsing in front of strangers. Daniel closed the notebook. I have one final exhibit. He turned toward Special Agent Kevin Marshall. Agent Marshall, during your forensic examination, did you recover any deleted video files from the defendant's phone? I did. Rebecca stood immediately. Objection. On what grounds? Content addition. Daniel responded before I could speak. The metadata device records and forensic extraction have already been authenticated through this witness. I reviewed my notes once more. He was correct. The objection was overruled. Daniel connected the phone to the courtroom display. Ladies and gentlemen, he said quietly, this video was never posted online. It was never sent to anyone. It remained deleted until investigators recovered it. He pressed play. The screen showed Emily sitting alone in her bedroom. She appeared relaxed. There was no sign that she believed anyone else would ever see the recording. She looked directly into her phone's camera and smiled. "I think it's working," she said. "My mom almost fainted this morning." She laughed softly, not loudly, not hysterically, just a quiet, satisfied laugh. Then she continued, "They keep saying it must be a virus." Another smile. "They have no idea." The courtroom froze. I have rarely witnessed silence so complete. Even the court reporter paused for a fraction of a second before continuing to type on the screen. Emily leaned closer to the camera. "The funny part is," she stopped, smiled again, "they still trust me to cook dinner." Someone in the gallery gasped. Another person whispered, "Oh my God." I immediately reminded everyone that emotional outbursts would not be permitted, but even I could feel the emotional weight pressing against the walls of that courtroom. The video continued. Emily looked thoughtful. "People always think kids don't know anything," she shrugged. "They never realize how easy adults are to fool." The recording ended. Daniel didn't say a word. He didn't need to. Evidence like that requires no dramatic explanation. I turned my attention to the jury. Several avoided looking at the defense table. Others stared directly at Emily. Rebecca slowly stood. For the first time since the trial began, she appeared genuinely shaken. She approached her client and whispered something. Emily listened, then unexpectedly, she interrupted her attorney. She stood. "Your Honor." Every head turned. "I want to say something." Rebecca looked alarmed. "Emily, sit down." But Emily ignored her. She looked directly at me for the first time since the notebook had been opened. Her confidence had not returned, neither had fear. Instead, there was something else, exhaustion, as though carrying her secret had become heavier than defending it. "I didn't think," she began quietly. Then she stopped. The courtroom waited. "I didn't think anyone would ever understand why." Those 8 words changed everything, because they were not a confession, not yet, but they were the first crack in the wall she had spent weeks, perhaps months, building around herself. I looked at her carefully. Years on the bench had taught me that truth often arrives one sentence at a time. The question was no longer whether the evidence was powerful. It was whether Emily Carter was finally ready to reveal the reason behind the unimaginable choices that had brought her into my courtroom, and what she said next would leave every person in that room, including me, speechless. There are moments in a courtroom when time seems to lose its meaning. The attorneys stop thinking about strategy, the jurors stop writing, the spectators forget why they came. Everyone waits for a single voice. That afternoon, the only voice anyone wanted to hear was Emily Carter's. She remained standing beside the defense table, her hands trembling for the first time since the trial had begun. Rebecca Collins quietly urged her to sit down, reminding her that she had the right to remain silent. Emily looked at her attorney, then she looked at me. "Your Honor," she said, "I know she doesn't want me to talk." Rebecca closed her eyes. "But I'm tired." Those 3 words carried a different weight than anything I had heard during the entire trial. Not tired of the courtroom, not tired of the lawyers, tired of carrying whatever had been hidden beneath months of carefully rehearsed confidence. I addressed her calmly. "Emily, before you say another word, I need to remind you that you are under no obligation to testify. Anything you choose to say can be considered by this court. Do you understand?" "Yes." "Have you discussed this decision with your attorney?" She nodded. Rebecca spoke softly. "I have advised my client not to make any statement." Emily answered before I could respond. "I know." Then she faced me again. "But she's defending the person everyone thinks I am." A heavy silence settled over the courtroom. "I need them to know who I actually became." Those words stayed with me long after the trial ended, not because they excused anything, they didn't, but because they revealed that, for the first time, Emily herself understood there was a difference between explaining behavior and escaping responsibility. I allowed her to speak. She never raised her voice. She never cried dramatically. She simply talked. She admitted that months before the poisoning began, she had become obsessed with control, not money, not revenge control. She described how she secretly enjoyed proving that adults believed whatever fit their expectations. Teachers believed she was the perfect student, neighbors believed she was the perfect daughter, her parents believed she could do no wrong. "Every time someone trusted me," she said quietly, "it felt like winning." I remember looking toward the jury. No one interrupted, no one even shifted in their seats. Emily continued. "It started with little lies, skipping homework, forging signatures, blaming classmates. When nobody figured it out, she lowered her head. I wanted to know how far I could go. There it was, not a dramatic motive, not greed, not hatred, a terrifying progression of choices made easier by the success of the last one. She admitted researching toxic substances online. She admitted keeping notes. She admitted recording the video investigators recovered. And finally, she admitted placing poison into meals prepared for her parents, not because she wanted immediate death, because she wanted to see whether she could control what happened without being discovered. The courtroom remained completely silent. No one celebrated the confession. No one looked satisfied. There was nothing satisfying about hearing a 14-year-old calmly describe treating her own family like an experiment. Then something happened that I will never forget. Michael Carter slowly stood from the front row. His body was still weakened from months of recovery. Laura Carter reached for his arm, but he gently pulled away. He wasn't angry. He wasn't shouting. He simply looked at his daughter. Emily finally met his eyes. For the first time that day, she cried, real tears, not dramatic sobbing, just quiet, uncontrollable tears. Michael spoke only one sentence. We loved you every single day. Nothing more, no accusations, no speeches, no bitterness, just that. I have witnessed families destroyed by violence, but I have rarely seen heartbreak expressed so simply. Emily covered her face. I know. Those two words echoed through the courtroom more powerfully than any confession. When it came time for sentencing, I spoke directly to her. Emily Carter, your age requires this court to recognize that you are still developing emotionally and psychologically. I paused. But your age cannot erase deliberate choices made over weeks that place two lives in grave danger. I explained that the purpose of juvenile justice is not only accountability but rehabilitation whenever possible. This was not a case that called for vengeance. It called for protection, treatment, and responsibility. I ordered her committed to a secure juvenile rehabilitation facility with long-term psychological treatment, educational support, and periodic judicial review as permitted under the law. I also imposed the maximum juvenile disposition available under the applicable statutes, recognizing both the seriousness of the offenses and the possibility, however uncertain, that meaningful rehabilitation could still occur before adulthood. Some people later criticized that decision. Others believed it was too severe. Some believed it wasn't severe enough. That is the burden of judging. You cannot sentence according to headlines. You sentence according to law. Years have passed since that case. People still ask me whether I believed Emily was evil. My answer has never changed, no. I believe she made a long series of intelligent, deliberate, devastating choices. The law held her accountable for those choices. Whether she ultimately became a different person depended on what she chose after the courtroom doors closed. If there is one lesson I hope you take from this case, it is this. The most dangerous warning signs are not always loud. Sometimes they wear a polite smile, sometimes they earn perfect grades, sometimes they become exactly the person everyone expects them to be. Character is not measured by how convincing someone appears. It is measured by what they choose when no one believes they are being watched. That courtroom taught me something I have never forgotten. Justice is not only about exposing hidden crimes, it is about exposing hidden truths, and sometimes the truth is far more unsettling than anyone was prepared to hear.